Back to the House Judiciary Committee. This Wednesday morning, April 24th, and we are looking at S-259. And we have Legislative Counsel Michael Grady here to talk about those issues that are in front of the Judiciary Committee on this particular bill. So
in our lane.
in our lane, right? Exactly. Yes. What is our lane? What are we looking at?
Okay.
I mean, this is kind of so we had testimony from a number of witnesses a couple weeks ago that really went into depth about the various legal issues such as preemption and retroactivity, strict liability, et cetera, et cetera, et cetera, as did Mike. But I just wanted to kind of go back over and kind of summarize those issues that we've had for us kind of in our jurisdiction. So
Okay. Well, there are a few. And damage requests that are potentially significant. So consequently, it will likely be litigated. There will be many arguments. I cannot tell you how a court will find because no court has addressed this bill or any similar type of bill specifically. That said, I think there are very good arguments that support finding that this bill satisfies any of the legal requirements that may be at issue. The first is due process. They're going to bring kind of several different arguments, I think, for due process. They're going to bring just a regulatory contacts argument because they're going to say that the extractors or refiners that are subject to the liability are not in Vermont or may never have been in Vermont. But both federal and state courts have said that when a manufacturer avails itself of the national market or engages in the use of a distribution system for the distribution of a product within to a state, and they have availed themselves of the jurisdiction of that state and have sufficient regulatory contacts for assertion of jurisdiction by the state. And I think you have that here with many, if not most, of the manufacturers and extractors and refiners at issue. With that said, the bill itself says that if you don't have regulatory contacts, you're not going to be subject to jurisdiction by the state. So the state has already recognized that they will need regulatory contacts for assertion of the cost recovery demand.
Are you saying context or contact?
Contacts. Like, it's like they literally have to touch the state, contact the state in some way. And the availment of the national market, when you know you're putting your product into the national market and through distribution or use of its specific distribution system itself. I just got done doing an extended producer responsibility program in House Environment and Energy. When I first did that program in 2016, a senator made me write into the finding sections what the regulatory contacts jurisdiction was in Vermont. And it's you avail yourself of that distribution system and you place your products into the stream of commerce in Vermont, you are availing yourself of the regulatory jurisdiction of the state. So I don't see that as an issue. There may be some that don't have sufficient regulatory contacts, like India Coal. I don't know if India Coal's products are ever reaching Vermont. And so that might be an extractor or refiner that isn't subject to the program. Then there's going to be.
Just can I ask a question on that? So a commodity like a fossil fuel is fungible. We don't, as I understand it, necessarily know, and please correct me if I'm wrong, because like that this bit of oil came from this refiner or, this bit of gasoline came from, because it is all fungible, sold on a mercantile exchange. Are there other examples where a refiner, for example, or something similar in another thing, and this is a novel bill, as you said, but are there other examples of commodity producers who are selling their commodity in a fungible manner on a mercantile exchange being shown to have minimum contacts when you can't draw sort of like a one-to-one, connection that, this oil was in Vermont and it caused the harm that we are alleging, if that makes sense.
Well, the program I'm thinking of is the Clean Heat Standard. It's not a program that creates a liability. It creates regulatory requirements. And I do think that's, I didn't draft that. I would have to go back and look at it, but I do think it has imposition of requirements based on the fungibility of the product. But I would have to go back and look at that.
Do you know, like, not in Vermont, like anywhere else in the nation where there's been, again, obviously this is a new idea, but where, I don't know, about corn or something, like, I don't know, I'm just trying to think of an example of a commodity that's just that there's been the minimum contacts test has been upheld by a court, even though it was sort of again, a commodity.
Not a commodity. The case that I'm familiar with in Vermont was an auto parts case. And they were selling and they were arguing that they were selling through a catalog. They didn't actually have a presence or sale, and they were arguing that the sale was occurring where they were located, and therefore there wasn't any availment of the market in Vermont. But the court said no, that they were using a distribution system, and that was sufficient contacts. Great, answer your question.
Yep, thanks.
So, Joe just made me think about, some of the plastics industry, for example. The base product within, plastics are utilized by multiple entities. So that product is actually visible and inserted every those types of.
Right. I mean, under the police powers of the state from the 10th Amendment, the state can regulate the health and safety of products sold in the state. And so the state does regulate the composition of plastics and plastic products that are sold in the state. Can't have BPA in it, can't have phthalates in it, can't have brominated flame retardants. The state does have that police power authority. Moving on this bill.
Sorry.
Yeah. Karen.
Yeah, so just in this discussion, this question came up for me of, because we're going retroactive, going back to, 95? So what if there are companies that are liable or responsible parties, but are no longer in business? Can they still be, have to contribute to, how does that work? Or couldn't it just be that companies sell and they're like, we're now a new company, we're no longer in existence, we were responsible, but I don't know how that works.
So the bill does provide that successors in interest of companies that would be liable would also be liable. If there's no successor in interest, and if the corporate entity and all of its liabilities and ownership is clearly just defunct, then yes, it will. There won't be anyone to impose a cost recovery demand to. You bring up an interesting point with regard to retroactivity. Generally, laws are prospective in nature, but underneath your constitutional authority and other legislatures' constitutional authority, you can provide that laws apply retroactively when you clearly provide for that. And frankly, you do it every year, multiple times a year, usually with regard to tax laws, but it's done very commonly in Vermont. And courts have held that retroactive liability is permissible as long as the retroactive application is supported by a legitimate legislative purpose, furthered by rational means. And there are courts that have said when the imposition of that liability is harsh and oppressive to the person or the entity that it's applied to, that it may violate substantive due process. But that is an individual fact-based determination for each entity that may be subject to liability. And there is a case out there. It was regarding I think it was a coal miner benefits case. And there was retroactive liability imposed, and it was imposed on a successor in interest. And the successor in interest was no longer a coal company, it was a parking lot company. And the court said that in that instance, the application of that retroactive liability was potentially harsh and oppressive. So that's kind of the standard you're looking at. It's hard to say that any imposition of liability would never be a substantive due process issue because it is so fact-based, but you're looking at these companies that have been in business for decades, been refining and extracting for decades, been distributing their products for decades, been knowledgeable of the effects of their greenhouse gas emissions for decades. This is not the same type of situation where a parking lot owner is being imposed liabilities for coal miner benefits.
Which I get, I guess I'm just trying to make sure that there isn't a loophole in all of this, right? That companies just started to sell off and have a new successor, maybe turn everything into parking lot things. Like, you know what I mean? I'm trying to say.
I do. And you never, I can never discount manipulation. But there are rules and requirements and ways that the state can pierce that type of effort if they try to start moving assets around in preparation for liability awards, et cetera.
So we feel like we're grounded in that, and that's covered with this, or to the extent that we can.
I think you look at this law through the lens of the state hazardous and federal hazardous waste liability provisions, CERCLA or Superfund as many refer to it, where that imposed liability on not just owners of land and not just operators of facility, but people who arrange for hazardous materials or transporters of hazardous materials to be taken to a site and then used at that site where they might have been released. And the courts have held the retroactive application of liability in those cases is constitutional. It didn't violate substantive due process. And when you read CERCLA cases, it's amazing how far they reach back. They reach back to like World War II, when like the federal government took over manufacturing plants in Los Angeles in order to make materials for the war. I mean, that's how far back CERCLA has reached. And the courts have said that that retroactive application is constitutional. With that said, the US Supreme Court has never addressed retroactivity under CERCLA. But I have to say, pretty much every circuit court has, and CERCLA doesn't have an express retroactive provision in it. You know how court said the CERCLA was retroactive? Because it used the past tense. When there was a material that was released, then the liability was applied to the owner or the operator who owned or operated at that time. And so if that's clear application of retroactivity, this bill, which is very clearly retroactive, meets that clear retroactive application standard, in my opinion.
So I know you haven't gotten to this yet, but in the testimony that we heard, whenever that was last week, there was a lot of discussion about being in state court versus being in federal court. And hearing from the AG today that her consumer fraud case, I guess, now finally after 2 years is going to be held. The jurisdiction is in state court. Does that bode well or say anything to you about this bill and its ability to stay in state court?
So I don't know that case well enough to say how it informs any potential litigation here. My belief is that this will be litigated in federal court. There will be facial claims about the constitutionality of the bill. There will be diversity jurisdiction. The manufacturers, extractors, refiners will mostly be headquartered out of state and will ask for anything that could be litigated at state to be litigated at federal because of diversity jurisdiction. So I think you're likely to see this be litigated in federal court.
I have one other question from the AG's testimony, which is, it sounds like Vermont is likely to be the first state to do this if we pass this and it's enacted. And I know from some of the bills that we did a few years ago, like GMOs, there was like, oh no, we're going to be the first state, we're going to have a lot of expenses. But on the other hand, after hearing from Representative Dolan, like being early on is also before people end up filing for bankruptcy or doing other stuff. So it seems like there are some advantages to being early doers. And I guess I'm wondering if you think that is true.
Vermont is trending towards being the first state to enact this legislation or similar legislation. Consequently, it's going to be the one that, if it is, it will be the one where the litigation occurs first. I do think it has an opportunity to set how this program is going to work and to be novel in how it implements this. One of the things I like about this bill from a both kind of a mechanics and from a litigation defensibility perspective is that it relies on the treasurer, the financial officer of the state, to do a report on what the costs to the state are. And that becomes part of the formula. So you will have a vetted product based on this financial officer's expertise with his contracted expertise, because he has asked for that as well. That will be part of a key part of the formula for assessing cost recovery demands. And I like that as how does a potentially responsible party say, this is inequitable, or this isn't based on fact? You will have a financial officer's report based on expertise that will be I like that as a defensible component of a cost recovery demand. So the things like that and the novel aspect of implementing a program. The flip side is the state will be sued and it will incur costs. I drafted the GMO bill. Personally, I know I'm probably going to be deposed and my records are going to be searched, and I'm going to have to, things that I don't find to be a benefit, but I'm aware will happen. And so others, you all might be subject to Public Records Act requests. There are pluses and minuses of being the first.
But there are pluses and minuses. It's not just minuses, which is, I think, important because I think, yeah, thank you.
Joe, I have a question, but I'm still formulating it, so it's not gonna be great yet. So I want to look at page, this is the as passed by Senate version, page 2, starting at line 12 and going through the end of definition of controlled group. So a controlled group, which I understand from page page 6, are the ones who are jointly and severally liable for this payment. Under subsection B, which starts on line 17, the entities in the controlled group are treated as a single entity for purposes of meeting the definition of responsible party and are jointly and severally liable. And then when we go to responsible party, which is page 5, lines 5 through 11, any entity or successor in interest to an entity that during the covered period was engaged in the trade, the fossil fuel trade. And I'm trying to wrap my head around, I was quickly looking at 26 USA 52 and I didn't get to 414. And I'm wondering if you could explain what the implications of declaring these entities as of the controlled group as being a single entity for the purposes of a responsible party and the joint and several liability. Why is that there?
So I just want to step back. The responsible parties are not necessarily controlled groups.
Okay.
They're going to be an entity as it's defined on page 3.
Okay.
So then an entity is responsible if they have attributable to them more than 1 billion metric tons of covered greenhouse gases during the covered period. One of the entities is obviously potentially a corporation. And there are corporations that are defined by the Internal Revenue Service as controlled groups, where it's really just multiple different corporations acting under the umbrella of another corporation. And the concern is that one of those individual corporations in the control group for taxation purposes of that umbrella would escape liability by saying no, that they didn't qualify as a responsible party under this. This, and treating those individual components of the control group as individual entities allows or doesn't allow for manipulation of the control group structure to avoid liability under this bill.
So basically like a conglomerate sort of with many different underlying corporations, then we're basically saying that this applies to everyone in every corporation, a conglomerate, not just a particular one.
That's right. And you see that on page 6. It's like purposes of the section entities in a control group shall be considered a single entity for the purposes of identifying responsible.
Thank you.
Were you gonna move, did you want to move on to something?
Well, yeah, well, I don't know how much longer we have, Mike here.
Okay.
So,
I'll ask my question later.
I'm sorry.
I'll ask my question.
Okay. I mean, one of the other things I wanted to talk about in retroactivity is there are constitutional provisions against retroactive application of laws. You probably know it best as ex post facto, that you can't criminalize behavior after the fact. And that's been ruled unconstitutional. There's another component of that. It's called bill of attainder. It's when the retroactivity that's applying is not necessarily criminal. And the courts have set up a standard for when bill of attainder, for reviewing whether or not an act is unconstitutionally retroactive because of bill of attainder. First, you have to look at whether it's a legislative act or administrative action, and this obviously is. But then you have to determine whether or not it inflicts guilt or inflicts punishment for a prior act on a specifically defined individual or easily identified members of a group. Now, as I referenced earlier, looking at this bill and the retroactive application of liability is from my perspective, seen through the lens of CERCLA. And CERCLA has addressed whether or not bill of attainder applies to that retroactive application of liability under that act. And the courts have said that what CERCLA is seeking is not punishment. It is not seeking to inflict guilt or inflict punishment. It is seeking to recoup damages for remediation of the harm that was caused by the activity. And that is what this bill is drafted to do. It is drafted to get a cost recovery payment for the share of the responsible parties' greenhouse gas emissions for the cost to Vermont from those greenhouse gas emissions. Remember, the state treasurer is coming forward with that report. What is the cost to Vermont? That is going to be part of the formula for assessing cost recovery payment. It is not a punitive penalty bill. It is a remedial recovery of damages bill for the cost to Vermont.
So is there any credibility to the argument that it may be damages to you, but it's punishment to me?
Yeah, I mean, that argument's going to be made.
Okay.
It will be made. But again, there is precedent out there for a similar retroactive application of liability where the court said, courts have held CERCLA does not exact punishment. It creates a reimbursement obligation on any person responsible for the cost of remedying the hazardous conditions. The restitution of cleanup costs was not intended to operate, nor does it in fact operate as a punitive deterrent. Here, like CERCLA, this bill creates an obligation to reimburse for the responsible party's share of costs for Vermont. That is how I see that through the lens of CERCLA and how courts have looked at CERCLA.
Are you able to say why the year was picked for the retroactivity?
I believe that there are a couple of different, it's a period where it can be calculated. Their costs, I think you took testimony from a couple of different scientists on that. And I also think that there's other equitable issues that may be involved, including knowledge in the industry of the effects during that period.
So there's a lot to hang our hats on with what that year was.
And remember, the covered period, it's now 2024 where it ends. That's not very retroactive at all.
Right. Right.
So I know you're supposed to be in another committee, I think right now, unless,
I can probably get there late. It's House Ag.
text Sharon and let know you're a few minutes behind. Angela has a question.
Well, my question is actually about the covered period. I asked a little more about
Sure.
that. I'm just wondering if you can say a little bit about how the period was, or maybe not so much the whole period, but how the endpoint was chosen and its importance or significance, and how it limits us, if it limits us. I just, it's interesting to, like, this seems like we're setting up a very important concept. And we're limiting it to this span of years. I'm guessing there's a very good reason for that. Then like damage will continue.
Right, and that's, I was gonna say, remember the covered period in the bill itself is about recouping the cost of the damages caused, right? And so this is the period the state knows of to recoup those damages. I think it's very possible that this period is extended in the future, once this bill is implemented, because the damages likely will continue.
So that's possible.
It's possible.
To extend that period.
Yeah.
Okay, that's pretty much my question. It just sort of knowing how long it will take to get through.
When this is implemented, we will know that there have been emissions and there have been damages from those emissions during this period. So it's a factual, the known entity, known period where there was liability, there was damages that the state can seek recovery for.
So nothing in the bill limits us from seeking damages for harm done after 2024.
I think if this is implemented and it works, held by the courts, I think it has a very good chance to, you will have opportunity to extend that period as a general assembly in the future.
So I know we probably wanted to talk a little about preemption, and were there other, but are there other, just tell me the big issues that we still have. With
Well, yesterday you said you wanted me to talk about strict liability, and then commerce clause would be the other.
Commerce clause and preemption. Okay, so because you have to go to ag, can you instead just walk us through a couple of questions? Can you walk us through the amendment, just so we understand what their amendment was from, and if you could pass that out for us. After we have Secretary Moore on, I'll ask Anthony to testify and answer questions about those other three issues, because he can talk to those. And are you going to be done, do you think, in Senate Finance before lunch that you can swing by here?
I have to go to Ways and Means.
In Ways and Means, I mean.
I hope so. I don't really know I'm going there, but that's usually a sign that it could go quickly.
Okay, all right. So maybe we'll have you then back after, just so we can wrap this up.
Yeah.
But so.
I just want to get to your website so I know that I'm using the right version of the amendment.
I think it's, yeah. Do you want a hard copy or?
I'm good. All right. So is everyone looking at 1.3 with a 4/18 date and a 106 timestamp?
Yes.
The first instance of amendment was really kind of a clarifying amendment in subdivision 21 in the definition of what is a qualifying expenditure. It had previously said that it would be something that would pay for reasonable expenses associated with the administration of the fund and the program, and as part of the support of a climate change adaptation project. It was confusing as what that as part of the support could be interpreted to mean. So it's now just shall pay for administration of the program and pay for support of a climate change adaptation project, not as part of anything. In the second instance of amendment, in section 598, the liability, there was some language about the installment payments and how that they were going to be implemented. It is on page 8 of the as passed by the Senate language. And it's just basically saying, it was basically about allowing to charge for interest on installment payments. Because remember, when there is a cost recovery demand, the responsible party can pay that demand as a one-time payment, or it can put 20% down and then pay the rest of the demand over 9 installment payments. And so there was a request that the secretary may be authorized to charge reasonable interest on each installment payment or payment delayed for any other reason at the secretary's discretion, and for the secretary to adjust the amount of the subsequent installment payment or payment delayed for any other reason to reflect increases or decreases in the consumer price index. Remember the formula, cost recovery demand is based on the cost to Vermont to do and to respond to these greenhouse gas emissions and the damages they cause. Say, for instance, the cost of concrete just like drops, and the cost to Vermont for flood resiliency projects and infrastructure will go down, then the secretary has the ability to adjust that installment payment to reflect the actual cost to Vermont based on the CPI. Moving on, again, still in section 598, there is an ability for a responsible party to ask for reconsideration from the secretary of a cost recovery demand. It's a fairly common thing within A&R, underneath A&R rules. If the secretary says you need a permit or you can't get a permit, before you go to court, you get to go to the secretary and ask for reconsideration by the secretary. As passed by the Senate, the responsible party was only given 15 days to ask for that reconsideration. To address maybe a procedural due process argument in the future that it was increased from 15 days to 30 days, that's pretty consistent with A&R reconsideration policies. So that is what that amendment on the top of page 2 of the amendment does. And then it's still in section 598 about liability. This is a clarifying change to basically the savings clause for any other right or remedy. The way that it was drafted as passed the Senate needed some improvement, because it had said that any existing remedies available to a person of the state, well, it really, you just want to use that default definition of person in Title I, which is pretty much any kind of legal entity that you can think of, an individual, a corporation, the state itself, a municipality. So that savings provision was first changed to say not existing remedies, it's any other remedies. So maybe there are additional remedies that are added after the fact, or after the effective date of this act. Those remedies would still be available to an injured party. And it clarifies that it's available to a person, as that default definition of person is defined in 1 VSA 128. So it's really clarifying language.
And we had testimony on that in this committee as well. So,
Okay.
yeah, so I'm agree with that one. Thanks.
And then the third instance of amendment, there are a couple of times where the term best is used as a modifier, and there was concern that that would create an opportunity to argue whether or not the methodologies used or the science used was the best available. So best was just struck, and it's adopting methodologies using available science. Science will be part of any litigation like this as well. And then the effective dates, to just clearly address the retroactivity of this bill, takes effect July 1, 2024, except notwithstanding the provisions on prospective legislation, the liability of responsible parties for cost recovery demands shall apply retroactively to the covered period beginning January 1, 1995. So clear statement of retroactivity notwithstands the general provisions in Title I that says laws are prospective and shall not affect liabilities that occur before the effective date. So that's what.
So you may have to save this question
Okay.
for when we get Mike back, because
Okay.
I want to at least give David Durfee 15 minutes of
Okay.
So yeah, if you could swing by after Ways and Means, if we can have you for a little longer and let some final questions. Appreciate it. All right. Thank you.
Thanks, Mike.
It's so helpful.
Okay, so we'll invite Secretary Moore. Thank you for being here. Introduce yourself for the record and proceed.
Absolutely. Good morning. I'm Julie Moore. I'm the Secretary of Natural Resources. I don't think I've had the pleasure to be in front of you, in fact, this biennium, so it's nice to join you this morning. And really appreciate the opportunity to come before you and offer my perspective as you continue to deliberate on S-259, as I was unable to participate in the joint hearing you held earlier this month. Specifically, I want to touch on the importance of this work, the critical importance of doing this work well, and what I believe is the work needed to ensure that what is really a novel approach to climate action has the greatest possible chance of success. I want to be clear at the outset that my remarks aren't about if we should pursue big oil, but rather when and how, and to do this in a way that hopefully yields the desired outcome. When 259 was first introduced, I went to ANR's team in our waste management division, who really leads our involvement in the federal Superfund program, which we use to address abandoned hazardous waste sites, places like the Jard Company in Bennington, the Ely Copper Mine in Berkshire, or the former home of MyTech Systems on Commerce Street in Williston. And appreciating some of the connections I just heard Michael make with CERCLA in reviewing 259, staff reflected that this bill really relies less on the legal framework of the Superfund program, but rather draws more heavily on natural resources damage assessment and strict liability to hold fossil fuel companies that extracted or refined petroleum products during that covered period, 1995 to 2024, responsible for the damage. I then reached out to some of the key researchers and experts that I know you've had a chance to hear from as well, and really appreciated the opportunity. I had to speak with Dr. Mencken at Dartmouth and look forward to connecting with Dr. Heedy in the weeks ahead to learn more about his work as well. Dr. Mencken also provided me with several working papers in this space, which explored the question of whether and how carbon emissions from specific companies can be linked to specific damages. And my takeaways from that is that this is clearly an area of active academic research and think tank work, an area where there isn't yet a whole lot of peer-reviewed work that has been published. It really is mostly in the form of these working papers, and an area where several other states, California, New York, Maryland, and Minnesota, among them, are currently contemplating similar approaches to holding fossil fuel companies accountable, but none of which have moved forward at this point. And so, I think it's important to keep in mind that the application of this legal framework to climate change and attribution will be novel, and it requires a lot of work on our part to be able to transition what is a conceptual approach into an actionable framework that will withstand legal scrutiny. I could also see in the literature, this is an area of science and research that is rapidly advancing, and there are several possible approaches to estimating the damage caused by climate change and assigning responsibility to fossil fuel entities. Further, most of this work appears to be being done at the national level, and I'm not sure about downscaling it to Vermont. Most of my experience is in the climate scenario modeling space, but I suspect there will be additional questions raised in trying to take a national data set and downscale it to our small state. Just a couple of other pieces that jumped out at me. 259 defines a responsible party as a fossil fuel entity that's emitted more than 1 billion metric tons of greenhouse gas emissions during the covered period, with a jurisdictional nexus to Vermont. And at this point, we haven't done the work to know exactly which entities would reach this threshold or what their emissions have contributed to the losses and damages in Vermont. So there's open-ended questions here. And those answers to those questions will help us be sure to select the best approach that ensures Vermont is properly compensated for loss and damages. But that's really only the first step. Once the preferred approach is identified, there are additional data needs and decision points that are required to compute the losses. And to do that, we're going to need access to validated data sets, including not just the list of fossil fuel entities that meet the definition of the bill, but information on the volume and type of petroleum products each fossil fuel entity extracted or refined during that covered period, emissions factors associated with the types of petroleum products that were extracted and refined, and that ability to establish a jurisdictional nexus between that entity and Vermont. And so it's important to consider the fact that whatever approach we decide to follow, knowing it will face significant legal scrutiny and challenge, that it needs to be robust and well documented. My recommendation throughout has been for the legislature to use 259 to direct this initial work and analysis needed for an eyes wide open selection of the approach, with giving us ultimately the benefit of having necessary data in hand, coupled with an evaluation that could be returned to you of possible approaches that would help enumerate the liability and likely cost recovery demand and help inform how best to proceed. Agency technical and legal experts are concerned with the timeline proposed or prescribed in 259, and that it will challenge our ability to provide a thorough and technically sound analysis. And that 259 currently charts a full course without having done this initial evaluation of possible approaches based on Vermont-specific climate concerns. Put another way, this is a complex book of work, and having a forced timeline has the very real potential to result in decision-making early in a field that is emerging. I also want to be clear that given the complexity of this novel analysis, the agency requires resources for contracted support to access experts that can help us with data evaluation and technical determinations that will be necessary to underpin our approach. And I'm concerned that the current appropriations contained in the bill are insufficient to meet that needs. There's resources for one limited service position within the agency, which certainly is necessary to help capacitate this work, but there is expertise required here that we simply don't currently have, in part because this is a novel set of circumstances. Also just want to flag a couple of specifics in the Senate passed version of the bill. One is around the requirement for registering entities that are responsible parties. I'm not sure if that's been discussed specifically here, but my question is whether we actually need to do that if we are planning to use publicly available data to inform the cost recovery demand formula. As we're learning from the Clean Heat Standard docket, registering entities is difficult.
It's in the bill, just.
Page 12, line 4 of the Senate passed version of the bill. And we just need absolute clarity around expectations in what gets passed. A second area that I would flag is also on page 12, line 6, which is the adopting the resilience implementation strategy by rule. And sort of what the sideboards on that, the resilient, if this is really focused on the criteria and procedures for prioritizing climate adaptation projects eligible to receive monies, I think that makes sense. But also in the bill, the resilience implementation strategy is described as a document to identify and prioritize specific climate adaptation projects that will be paid for from the fund. And I'm concerned that the rulemaking process is time consuming and resource intensive. And to the extent we're being project specific, it will be challenging to go through the full rulemaking process each time we are looking at a batch of projects. I'm also not clear that there are examples of that level of detail being adopted by rules. Most rules sort of provide those framing requirements and then legal obligations. So I guess I would sort of wind down by saying there is a lot of devil in the details here. And I feel strongly Vermont and Vermonters will be best served by taking the time needed to do this work thoughtfully and to maximum impact. And as I said at the outset, to me, this isn't a question about if we should pursue big oil, but when and how, and to do this in a way that offers the greatest chance of success. Because there's no real value in being first if it comes at the expense of achieving the outcomes we all want and need for Vermont. And there is a lot of work that lies between where we sit today and where we will need to be to achieve that goal.
So appreciate the testimony. A few things before I open up for any other questions is, so I do understand in the Senate that that the Agency of Natural Resources went and requested certain timelines, and that was provided. And now those are not seen as sufficient. And that's fine because things change and you get more information. but also in in our environment and energy, that they didn't choose to change this either. And this isn't really where you have the timeframes and such is not really this committee's jurisdiction. It's really environment and natural resources. I'm not exactly sure how the Senate works, so I'll just leave that at that. So there's that. I guess the second thing is that there is, some long timeframes in here already, and there's always can be check back that if next year, we don't know what the appropriations or what the budget's going to look like. And if you don't get the resources to do it, we can't expect you to get it done. So there can be adjustments as well. And I know as far as, yes, I am concerned certainly about making sure we have something very defensible. We're talking about the bills going out to the companies well into 2027. So we have quite a pretty good long time frame to also be able to adjust that time frame. So that's kind of one thing I want to say. The other is that I'm not in a position to I need to kind of move this from this committee today because we're almost at the end of the calendar. It's calendar math and getting these things actually through. But if this was in my jurisdiction, we could do something about it perhaps, but it really isn't. So my suggestion, I want to be moving this out, but this is going to go to another committee, appropriations, which is one that you definitely need to talk to about the amount of money. And in the interim, I would suggest touching base with Amy. I'm happy to be part of a conversation as well to see if there is some adjustments that make sense. I would also probably talk to the Senate as well, because we want this to have a smooth pass. But I hear your concerns. I understand. We want to make sure this is defensible as well.
Thank you.
But that would be I'm not in a position to change from what you were talking about here. But we still have another stop, and we can work perhaps to see. And I'm not guaranteeing that this is a change whatsoever. But that's kind of at least where I see where we're at. So Barbara, if you have a question.
Thank you. Thank you for coming and testifying to us. So I know you mentioned that this is a new field, and I was just looking back at the notes that I took from Justin Menken's testimony, and it sounded like the methodology has been peer reviewed.
Temperature, not for the kinds of impacts Vermont is most likely to see.
So I've got to say, he provided a lot of sort of context in a short period of time. I realized he had to go teach a class, but he seemed very confident that the field and the research is really able to do this. And I feel like we did get to ask a couple of questions, and part of me is like, oh my gosh, we should just contract with one of his many outfits to do this work rather than have A&R become research experts in that. So I'm just wondering if there's anything I felt way more relieved about the research, and maybe I just missed the part that you were concerned about. So I wanted to ask about that.
Sure. Yeah, so in talking to Dr. Menken, my understanding is the methodology he's developed is really looking at the impacts of heat and extreme heat, and he is able to quantify, as you're indicating, for the 5 highest heat days, the sort of effect that is having on the economy, right? And he said to me in our conversation, this is a methodology that's really well suited for places like California. It's not a straight line to get to what the impact of the next 5 millimeters of precipitation is. And flooding are obviously our most costly impacts. So it's not to say we don't have temperature impacts. I think we absolutely do.
Yes.
But that the ones that are sort of most obvious, I think, in the minds of Vermonters, probably in light of last summer in part, are around flooding, and that loss and damages methodology he's been developing isn't yet ready to to take on flooding. It's not to say it can't get there, but it's not there right now.
The other thing is, he sounded like could get very granular about how it impacts Vermont. So I was sort of like, oh, is it going to be like this blue Corvette had, so. So anyway, so that was my main question. And for sure, I know that we have had timelines change as things change or resources aren't available. And my worry when we don't put a timeline in is then we don't have a deadline. And I get that they need to adjust and it's not our lane. So I'll stop asking.
That's fine. Other questions? Ella?
Thanks. It's great to hear directly from you about the bills. Thank you
Sure.
for being in our committee. I guess I just wanted to ask you to express a little bit more detail about the comment you, excuse me, made towards the early part of your testimony about data, particularly about the differentiation between like think tank papers and peer-reviewed research. As a scientist by training, I think think tanks is having a really different role as peer-reviewed research. So I'd just love to hear a little bit more about your concerns there. And I guess I concur that I think over the next few years, we're going to have to be engaging with research. This
Yes.
is going to require immense engagement with folks in the research community.
Agreed.
And that think tanks are sort of in place to sort of take peer-reviewed research and help apply it and creatively think about how to use that research. So yeah, can you just share a little bit more or also maybe an example of where, what you'd want to see?
Sure. So one of the papers, I'm actually going to just flip to it so I can
Sorry,
cite
I'm in
it.
the science
Of
realm.
course.
No, that's okay.
I think it applies to liability and defensibility. Yeah, defensibility.
So one of the papers that Dr. Mencken had shared with me is a working paper from the National Bureau of Economic Research. And that this is, these aren't policy recommendations at this point. They're sort of interesting concepts and approaches and frameworks, and they're being put out for folks to debate and wrestle with and refine and ultimately perfect and apply. And so we're in the early stages of that continuum where you move from something that seems like a kernel of an idea to something you could actually operationalize. And there are a lot of unanswered questions in these working papers, right? They talk about, in the one I read, it talks about one of the decisions you have to make is the discount rate. And it shows the enormous impact different discount rates have on both costs that have already been incurred and costs you might expect to be incurred as a result of emissions taking place between 1995 and 2024. And so they're able to tell you what the range is in that space, but there isn't necessarily a recommendation about what number is most defensible and why. I think the same thing is true on the social cost of carbon. That's a little bit more dialed in. EPA has a paper that they put out, I think at the end of last calendar year, that contains some additional documentation. But again, that's a specific assumption that is used to populate these cost formulas that has dramatic influence on the number that comes out the other end. And so it's that not just the formula itself, but the values you're plugging into the formula and having the background and justification for why you've selected those numbers is going to be critical to this work. And that to me is where the gap sort of sits currently, that you can look at these papers with these complicated formulas and get a sense for what the math is, but not how you would replace those variables that are there with actual numbers to yield a dollar figure on the back.
Yeah, I guess when there's those ranges, the bottom of the range is usually very, there's really not a question below that range. So even if you're being very conservative, and my understanding is this approach is a pretty conservative approach, we're not gonna, because there's that range, if you take a conservative approach and go after compensation for, at least that baseline, it is not arguable and doesn't have that statistical variation
I agree.
There's
I
basically-
think there's also a sort of a risk reward calculation that then would need to come back to the General Assembly, right? Which is if the dollar figure that comes out by layering conservative approach on top of conservative approach on top of conservative approach is relatively modest and the legal risk to the state is very high. That's a set of decision points too. And I guess that is what have been advocating for, is to do this initial work, bring it back to the General Assembly, and then have another set of conversations about what the next steps and realistic timelines are as a result of having benefit of some additional information.
Thanks.
Other questions? Don't see any other questions, so thank you very much for
Thank you
such
for
short
having-
notice being able to be here. Thank
I
you.
appreciate it.
So, we've already had a break, so we'll just go now. Anthony, if you could join us as well, and I do want to get focused more back on some of the legal issues, but welcome to hear as far as rebuttal or not rebuttal, but any comments regarding what we just heard from Secretary would be, we can start with that, and then we can get back to the legal issues.
Certainly. For the record, Anthony Arapino, lobbyist for the Conservation Law Foundation, and appreciate the opportunity to speak to you again. One of the things that the Senate did after hearing similar concerns from the Secretary was to agree to the agency's proposal of an interim report in January of 2025. And I think that was wise because it does give you an opportunity to course correct if it turns out that there is a need for such course correction. But going to Representative Rachelson's comment, it is also important to set some hard deadlines to make sure that people are working in earnest. And in fact, this morning, I connected the Climate Action Office with Richard Heedy, who is the witness that you heard from about the part of the work that actually belongs to ANR. And I do want to emphasize a point there because a lot of what Secretary Moore was expressing some concern about is the part of the work that's assigned to the treasurers.
I was wondering about the
Yeah.
discount. I was going to ask her, but I don't know why I didn't. But yeah, it sounded like some of those financial issues are in the treasurer's.
Yeah, and as you heard from your counsel, Mike O'Grady, it's an important feature of the bill that those types of decisions and analyses actually be lodged with the treasurer. Of course, the structure of the bill requires the treasurer to consult with ANR and any other experts within state government, as well as appropriate some money for experts outside of state government. So just keeping in mind, that is the treasurer's job that the secretary is expressing some concern about, where the treasurer has expressed some confidence, even after hearing from the secretary, that his office could do the job with some contracted resources. And in terms of the resilience adaptation by rule timeline, that was actually something that ANR requested in the Senate. So it's a little confusing that they don't want to do their resilience adaptation strategy by rule now. I don't think it's critical to the bill, but it actually, from a legal standpoint, taking action through rules provides greater legal insulation for them. As you may know, the way to challenge a rule under our state laws, it's a very narrow process. It goes through LCAR. LCAR has its lane, as your chairman said, to make sure it's not arbitrary and capricious and to make sure that it's not beyond statutory authority. But failing that, the opportunities to challenge a rule are fairly narrow. So there is some wisdom in the current structure of the bill to put the resilience adaptation and implementation strategy through rulemaking. And again, it's always subject to the interim report from the agency next year. So those are some key points. I do want to just also say, though, I looked back as we were talking about at the Professor Mankin's testimony, and I don't think he was just speaking to his own work. He is one of many colleagues in a field, and what he had said, and I'm quoting from his testimony, if that's okay. Our approach isolates and quantifies particular climate damages attributable to particular emitters, and owing to its modularity and flexibility, can be applied to myriad contexts, from single events to cumulative harms, emitters from individual firms to nations, and climate change driven hazards from average temperatures. So certainly that is there, and that's what he's worked on, but also heat waves, storms, droughts, floods, and others. And these are all interconnected ecological phenomena as well. So I think he has said that his framework uses consensus peer-reviewed methods and resolves nonlinearities, it's not a straight line, in the relationship between greenhouse gas emissions, atmospheric concentrations, temperature changes, physical hazards, and damage. So he's, all due respect to our secretary, she is a generalist. She's very good in her engineering field. But you did hear from one of the world's leading experts on this topic, and I think he did express confidence, and I don't think there was a financial motive there. He's got plenty of grants to keep up with his work. If the treasurer needs some help, I'm sure he'd be glad to provide it, but I think he's a credible source that you should move forward and have some confidence on. So thank you for the opportunity to speak to those points. Now, you wanted to cover some additional legal.
Just any questions on the science part? That really isn't in here, but it's kind of interesting, and I'm happy to have questions if anybody has questions. Go ahead.
Well, it's not actually, it's the section of science and legal, I suppose, but I just want to make sure I'm understanding what you're saying about rulemaking being where it is, that we would change it, but, or I'm sorry, the implementation plan going through the rulemaking process. I'm hearing you say that that provides some insulation to the implementation strategy. And I'm wondering if you can say a little bit more about from whom or what.
Sure, from any challenger, really, legal challenger, but if you think about the rulemaking process, it has a robust public participation comment, which means those who are potentially affected by the rule, such as the largest fossil fuel extraction and refining companies in the world, they have due process opportunities to show up, participate in that process, to critique data models, to provide better information if they have it. And they need to take advantage of that opportunity to make sure that the rule that's passed is fair. And if they don't, a court's not going to look very kindly on arguments that sort of are sandbagged, come out of the woodwork when the state has run a very robust process to hear from interested parties to figure out the best and fairest way to adapt a policy. So that piece of it is important. The public notice and comment piece, the opportunity for all potentially affected parties to come forward with information that they think is reliable and credible to help the state do its job. And then the second component of that, again, building on the first, because you've had such a robust process, because those who are affected have an opportunity to participate and be heard, the judicial review, any challenge to rulemaking, is done on a very narrow grounds. And the question is really, has the agency exceeded the authority that the statute gives to it? So did the agency stay in its lane, essentially? And did the agency do anything that's arbitrary and capricious? And that's a very high bar, because technical agencies like the Agency of Natural Resources or the Treasurer, they are due deference by the courts, because the courts recognize, hey, look, we're just lawyers wearing robes. We understand the law very well, but the science and these technical things, this is the provenance of the experts in state government. And so we have to defer to their judgments unless they have done something that's totally off the wall. And I think from the sober-minded presentations you've heard from our secretary just now, I think you can take her level of anxiety as a positive, because it means that they are going to be working hard to get it right. And I've seen that at the staff level as well. They've been, like I said, they've been engaged with us. They've been asking for contact information for Rick Heedy. And recall, that's the job that A&R really has to do. They have to figure out how much each firm is responsible for in terms of attributable emissions and what percentage of that it comes to from the overall cost that the treasurer calculates. And again, that work has largely been done. That work has been out there for, and that work is peer reviewed, and that work has been out there for many years. So it's really A&R's job is more plug and play with an existing data set, whereas the treasurer does have a harder job, but the treasurer has, in consultation with international experts, expressed great confidence about his office's ability to do that.
So I should have asked the secretary this, but you made me think of a question that I had for her, which was, it sounds like registering companies is like a big thing, and I didn't really understand what that was about. Like when she said it's very time they've learned from the other work that they or have to register corporations.
I'm not entirely sure. I do know about the clean heat standard because I was involved in advocating for that. And what I would say is potentially the issue is that there are many more entities that are potentially affected by the clean heat standard than are, we're talking about a relatively discrete handful of large corporations whose entities are known. But again, these rules are more than 2 years out.
Right, yeah.
So to the extent that they're learning lessons in implementation of the clean heat standard, the hope would be they apply those lessons to registration at the when it comes time to make this.
And what are they registering for? Is it like we've done business in Vermont, in which case is it like a form that the entity fills out?
Yep, we've done business, we've sold a certain volume of fuel. That's at the clean heat standard, that they've sold a certain volume of heating fuels. But thank you for your question, because it does touch on the other piece in terms of the nexus piece. And that nexus piece, the jurisdictional part that Mike was explaining, that regulatory contacts with the state, I do want to point out that the analysis is much the same for the consumer fraud suit that the AG's office that the Attorney General discussed with you before. And so the good news is of some of the very largest, those that are likely to be responsible parties under this bill based on their amount of emissions. I just throw out some examples: ExxonMobil, Shell Oil, Gulf. The AG's office has already asserted jurisdiction over these companies because of the fact that they likely have gas stations in Vermont. They likely have marketed to Vermont consumers. So we know that, the analysis isn't done. It's not necessarily exhaustive, but when the A&R goes to do this work, they have work product from and that is the legal expertise of the Attorney General, not A&R. They have the benefit of the work that the AG's office has already done to identify those companies that have regulatory contacts with Vermont. Could be that there are others, because maybe some of those others didn't engage in the kind of fraudulent behaviors that the AG's lawsuit is about. So it's possible that that's an incomplete list. It's very likely that it's an incomplete list. But the point is, some of the largest fossil fuel extraction and refining companies, the AG's has already said we meet the jurisdictional minimum contacts test for those companies.
And again, this isn't necessarily an R lane, but does that registering process have to be an A&R thing? Could it be a treasurer thing or a secretary of state thing or somebody else? I don't know.
I'm not an expert on what it is that they're trying to do, but I think what I expect is that the interim report that is in the statute issues like that, and give you an opportunity to make corrections on the margins if those are called for, to design the best program that comes at the least burden to the state. And one other thing I do want to point out in terms of the costs, your Senate colleagues did amend the bill as introduced so that costs of administering the program that fall to A&R can ultimately also be recovered from the fund. So that's part of the hope. What of the legal? I'm sorry. What of the?
Did you have
I'm good.
Yeah, so I think we didn't cover preemption and commerce clause, and just strict liability, just reminding us on what strict liability is and how we already have that statutes.
Okay. I'll start with preemption, and it's important to recognize that this idea for holding these fossil fuel companies accountable for climate damages originated at the federal level. Senator Sanders, Senator Van Hollen, Senator Warren, and others proposed as part of Build Back Better that the federal government enact this at the federal level. And if the federal government had done so, we wouldn't be here talking to you now. Clearly, there would be preemption because your police powers that Mike referred to before that are guaranteed to the state under the 10th Amendment to protect the health and welfare, including the economic welfare of the state, are very broad. However, when the federal government exercises its narrower powers, but does so in a way that occupies the entire field of a subject, such that there's no room for states to operate on the margins, there's clear case for preemption. So if the federal government had enacted a program like this at the federal level, they would be on behalf of the states collecting the kind of damages and then redistributing those to the states. It was a great idea that Senator Sanders and others supported. It didn't get over the hump because of the entire Republican Senate caucus and the fossil fuel magnate Joe Manchin, who is the senator from West Virginia. And unless something really fundamentally changes in 2024, I think it is very unlikely that Congress will step up on behalf of the American people and do its job. So it falls to you to step up on behalf of Vermonters and do your job. And because the federal government hasn't enacted that statute, there's a clear path to do what you're trying to do here, which is recover climate damages from responsible parties. That's not what the Clean Air Act does. That's the only other statute that you could think of that might preempt what you're trying to do here. The Clean Air Act is about prospectively controlling pollution from different sources through the implementation of specific pollution controls, technological approaches largely. Okay? So two different ideas. One, there is a federal statute on, which is controlling emissions from specific sources. The other, there isn't a federal statute on, which is recovering damages that have resulted from those emissions to natural resources and economic and public health. So the absence of a federal legislation on this is a good thing. And in fact, when the Supreme Court has recently looked at issues of whether there's preemption, they study what's called negative legislative history. And that is essentially you proposed an idea, but you didn't enact it. That says something about your understanding of what the state of the law is. If the Clean Air Act had already covered and been sufficiently broad to have a program like S259 sets up under the Clean Air Act, if EPA had that authority already, there'd be no reason for Congress to propose this standalone federal polluter pays climate law, which they considered and didn't adopt. So that's a significant point of analysis for even the conservative majority of the current Supreme Court. And given the difference between the Clean Air Act and what S259 is trying to do, the fact that there was a federal proposal to do what S259 is trying to do and that it wasn't passed, I think we have a strong argument to make. Also building on the fact, as you heard from Professor Rushlow, that this is not like any other damages action that's been brought. This is the legislative branch making informed policy judgments with help from experts in the executive branch. It's not asking a judge to decide all this, to figure out how the money gets spent, what the money gets spent on. You're using your policy judgments to do that. So when you combine all those factors, it would be my opinion that you have a very strong defense to any claim of preemption. Layering onto that, even if they were likely to argue that the Clean Air Act preempts what we're trying to do in S259, the Clean Air Act has a very specific savings clause, which recognize and respects state authority, and except in very specific areas. One of those is auto emissions. Okay, you can't just willy-nilly regulate what comes out of the tailpipe. That's at the federal level. California can enact some regulations, and Vermont has followed those in the past. But when Congress wants the states to stay out of the way, it very clearly knows how to say that. And when Congress wants the states to continue as the laboratories of democracy, it also knows how to say that. And when it comes to the Clean Air Act, they've given the states wide berth. And again, not even the same type of legislation, but even if the argument pertained that it was the same type of legislation, there is that very express savings clause that allows you as state legislators to do what you see fit to protect the public health and the environment of Vermont and Vermonters. So that's my answer to preemption.
Questions on preemption?
Super.
No, don't see. So.
Okay. So the next is the Commerce Clause, which is a part of the Constitution that basically assigns the regulation of interstate commerce to the Congress. It doesn't say anything about restricting state authority, but that is the way historically the Supreme Court has interpreted. And really, the way that Commerce Clause challenges arise are there's essentially two major grounds. First is they're trying to make sure that state legislators are not putting the thumb on the scale in favor of an in-state actor versus an out-of-state actor. Essentially, are you discriminating against out-of-state actors? Is it economic protectionism? And in this case, that's pretty simple because there is nothing that is protectionist about this bill. You treat all entities that refine and extract petroleum in the same way. It is a coincidence, a happenstance that there happen not to be any in-state, purely Vermont headquartered companies that engage in extracting and refining fossil fuels. But you didn't set this bill up to create an advantage for those companies had they existed here. Our bill is very similar to and just to go to the earlier question, to the New York bill, to the federal bill, to the California bill, which has come after our bill, the Maryland bill, and the Massachusetts bill. They're all neutral in terms of in-state, out-of-state. It depends only on the activity and the volume of the activity that you engage in. Has nothing to do with where you're physically located, other than the happenstance of where you've chosen to be located. So that bar having been cleared, that is the high bar in the Commerce Clause analysis. That is the real risk area. We are outside of that risk. There is still an analysis to be done about whether, even if your statute is non-discriminatory, whether you're imposing a burden on interstate commerce that so significantly outweighs the benefits on the local side that you've sort of strayed away from your constitutional authority. And on that, there's been a recent case, California. It's called National Pork Producers versus California. This is actually covered in Professor Rothschild's memo, which is in your record. So I encourage you to go back and look at that if you want. But basically, 5 justices of the court in that case said, it's okay for California to reach beyond its borders and regulate how pork is raised, pigs that will ultimately be pork is raised, to essentially impose humane animal husbandry standards on the industry, regardless of where they're located in the country or internationally for that matter, if California reaps a substantial local benefit. And in that case, one of the most conservative justices, Amy Coney Barrett, she sided with the majority in saying it's okay for California to reach outside its borders, even if there is a substantial economic burden on the industry by making them raise pork in a more humane way. And she said, you have to put the moral judgments of the state of California, as reflected in their statute, on the scale right alongside dollars and cents. That it is okay for California to make a moral judgment about how animals should be raised, even if that has a significant economic impact on the industry from an interstate commerce perspective. So really what the takeaway from that case has been is it's less this balancing test that has historically been part of Commerce Clause jurisprudence is less important than it has historically been, number one. But number two, even if it were still a factor, we are talking about, and you've heard testimony, and your colleagues in energy environment heard even more testimony about the kinds of climate damage Vermont is suffering and the dire need for financial assistance to help us recover and repair those damages, those that have happened now and those that will occur in the future. And when you put that on the scale up against the impact that might happen to the enormously profitable fossil fuel extracting and refining industry, which is having record profit year after record profit year, I think the balance in terms of the local benefit outweighs any incidental benefit that there might be on the national marketplace, particularly in the wake of the national pork producers case and how it's de-emphasized to somewhat this balancing test. So again, I think you have been careful in not being discriminatory, not because you're trying to let any Vermont companies off the hook, benefit any Vermont companies, just because we don't have any companies that do that here. And once upon a time, there actually were. I've done part of my legal practice. I do a lot of work in the land records, and there is actually, like, you will come across oil and gas leases from early part of the century in Vermont. I don't think we ever ended up having what Pennsylvania or Texas has. But again, it's just a happenstance. It's not an intentional choice on your part to discriminate against out-of-state companies to give in-state companies a benefit. So as long as you're clear that major hurdle, and given that the local benefits from recovering from the climate damages that are significant outweigh any impact on interstate commerce, I think we have, as Mike said, and the Attorney General said, we have some good faith arguments to resist challenge on those grounds. So I think you've done your due diligence. She didn't say it in this committee, but she did say to the Senate that she commended the Senate on the witnesses they heard in terms of the exploration of the legal issues. And obviously the Attorney General is somewhat more tight-lipped because of her future role as the, but you've heard the same witnesses on the legal issues that your Senate colleagues heard. You can certainly check my say-so against the Senate record. But I think you've done your due diligence to make sure that if you are, when I hope, Vermont takes this innovative step, I don't think we'll be alone for long, but to the extent that we are alone for any period of time, you can look your constituents in the eye and say, we have a case to make against these companies that have caused harm here. We are going to defend it with everything we have.
Did you want to just hit on strict liability just very briefly?
Sure.
We're familiar with it, but we may as well.
Yeah. So the idea is that strict liability attaches to an activity regardless of intention or fault or negligence. The concept is, did you or did you not engage in the activity? And so for hazardous chemicals, in statute already, you've assigned strict liability to manufacture of hazardous chemicals that end up causing natural resources damage in Vermont. You don't need to show that the manufacturers wanted to do that damage in Vermont. You don't even need to show that they were negligent in doing that damage, that there was some standard of care that they fell below. You just have to show that they engaged in the activity that's regulated, and as a result, they are going to be held strictly liable. It is very common, a standard in products liability, and you could, even though Mike has said, this is something of like a CERCLA context, it's not dissimilar to your product. You put a product out in the marketplace, you profited from putting that product in the marketplace, and that product caused harm. So you're strictly liable for that because we need to recover damages for that harm.
So does it matter that they had knowledge of the harm that was happening? That comes up frequently, but that's actually not even really necessary. It makes it easier to impose strict liability on somebody if you know that they do the harm.
Well, you have done that in the manufacturing of hazardous chemicals. You've expressly said that strict liability attaches only to those parties that knew or should have known. I don't think you need to do that here, though, because of the retroactivity. The due process analysis that Mike referred to before incorporates that test. It incorporates the test of, did you know or should you have known? Should you have known piece is important because that is what lawyers refer to as an objective standard. It's not, you don't have to prove knowledge on a company by company basis. You have to prove that the state of general knowledge was such that even if you didn't have some in-house particular scientific paper on climate change, there was enough out there in the world that you had your head in your sand if you didn't know that your fossil fuel products were contributing to climate change. And that goes to Representative Arsenault's earlier question about why 1995 is chosen as the beginning point. And that's something that my colleague Ben Walsh testified to in Environment and Energy. And it has to do with, look, there's no perfect date to pick. And as Michael Grady pointed out, CERCLA, which doesn't pick an end date, has gone back as far as World War II. But we think, to be conservative, 1995 makes sense for a number of reasons. Number one, in the years leading up to 1995, there was a growing general public awareness of the climate change connection with fossil fuel combustion. You had James Hansen's testimony to the US Senate in 1989, the very famous NASA scientist who very clearly testified that climate change was happening. It was linked to carbon emissions from fossil fuel combustion, among other sources. Then you have, in the early 90s, the first intergovernmental panel on climate change. So that's the international group of scientists, the cream of the crop of climate scientists, putting out their first report about climate change was happening. These are the kinds of damages we are seeing and can expect. It's coming from fossil fuels. Then you have the international community coming together and adopting the UN Convention framework on climate change. It also happens to be the period of time at which the atmospheric concentration of carbon exceeded the 350 parts per million threshold that scientists have said was kind of the point of no return to save us from the kind of damages that Vermont is experiencing. In fact, 1995 was at the time the warmest year on record in the history of the planet as we know it based on the scientific data. Sadly, that record has been broken time and time again, and scientists say it may be broken again this year. But there were just so many alarm bells going off by 1995 that there's no way for a fossil fuel corporation who's in the business of extracting and refining at a scale that results in more than 1 billion metric tons of attributable emissions to credibly say, we shouldn't have known, we couldn't have known by that point. So that kind of addresses the strict liability factor of knowledge as an objective test and the historical reasons why, to be conservative, knowing that a legal challenge is coming, we sure could reach back earlier in time, but 1995 feels like an imminently defensible place to start the period for covered period for strict liability.
Can I?
Yeah, go ahead. Yeah, absolutely.
Thank you for that explanation. That's super helpful. And my question was actually more about the endpoint of 2024. And so, Attorney O'Grady assured us that the bill leaves open the possibility of extending the end date. Is that your read as well?
Well, I think the reason why it's structured as it is because you have to allow the treasurer to produce a number, and to do that, there has to be a discrete time period. So once that's done, if the approach is validated from court perspective, there's no reason why there can't be additional iterations of the legislation if damages continue to occur, and we know they will. So the key question now is you have to establish a program over a finite period of time to allow for us to, vet the legality of it and the novelty of it. Again, we were drawing from the federal model that did look at a fixed period of time. But when we clear the legal hurdles that we need to clear, I think you can come back to this program and look at, are we continuing to incur damages? Do we still have responsible parties out there that can help make sure that the taxpayers alone are not the ones suffering these damages? Certainly, I do agree. But I think from a practical standpoint, you have to start with a finite period to give the treasurer something to work with. And once the treasurer has sort of built up that scientific policy muscle, you can have that office flex it time and again, but let's take it in steps.
Other questions? I think we've covered it fairly well. Thank you very much.
Thank you for the opportunity.
So do we have additional questions for Mike O'Grady?
I have one question, which it's not huge, but I'm wondering, Karen had asked about companies that aren't around any longer. I'm wondering about people that moved out of state that had damage during that time period, like, and that's not the hugest question, but it just led.
As far as the distribution of any funds that come in to pay for damage, which, I mean, I think that my understanding is that would be part of what's being sorted out by the treasurer, right? Is that right, Anthony? Yeah, why don't you come back and maybe you can actually.
I'm sorry, I didn't quite.
Go ahead and ask the question.
So I wondered about people that were living in Vermont between 1995 and whenever, that no longer live in state. Like, are they, because the bill keeps talking about the people in Vermont. And I don't know if that includes people that were in Vermont in that time period.
So the first thing I would point you to is the savings clause, which your colleagues amended in Energy and Environment to make sure that if there is another remedy, someone who's not covered by this doesn't stop them from pursuing individual remedies that they themselves may have. The second thing I would say is what the money is going to go to. And this is important from the standpoint of its defensibility, is climate change adaptation projects. And that's defined right there on the first page of the Senate as passed bill. It's a project designed to respond to, avoid, moderate, repair, adapt to negative impacts caused by climate change and to assist human and natural communities, households, and businesses in preparing for future climate change-driven disruptions.
Isn't that in addition to damages or no?
No, it's what it's what the funds collected will pay for. So those include nature-based solutions and flood protections, home buyouts, upgrading stormwater drainage, making defensive upgrades to roads, bridges, railroads, undertaking preventative healthcare programs and providing medical illness to treat illness or injury caused by the effects of climate change. It's a long list. I won't read it for you. I think the question of what projects are eligible, that is something to be worked out in the rulemaking. And to the extent that there's a concern that people who've experienced harm are no longer in the state to benefit from the program, I would expect them to work that out in rulemaking if that ends up being a big issue.
And a big thing that we didn't hear related to the Bennington Gilbane situation was medical monitoring. And I haven't seen anything about medical monitoring in here, and I don't know if that's a thing or if that would also come up in rulemaking.
Yeah, it's that language, I think, that undertaking preventative healthcare programs and providing medical care to treat illness or injury. I don't know if the monitoring piece is in there. I think that's probably at a level of granularity that goes to rulemaking, because like totally appropriate for the PFAS, well, because I think there was a well understood risk there, but I think we've got to see what the treasurer comes up with. Remember, the treasurer's got to come up with costs based categorized after consulting with a wide range of experts, including the Department of Public Health. So I think that's at a level of granularity that let the treasurer and the Department of Health confer on what are the kinds of illnesses that we know they're out there. I know there's some great UVM doctors and professors who've published on the climate effects of healthcare, but let them sort of get, there's only so much you can bite off at the legislative level. Let those folks and those physicians and medical professors weigh in and help the executive branch implement the full breadth of what you've put out there. And I would say the language in what a climate change adaptation project is broad enough to include medical monitoring if there's actually a scientific link to some diseases that are related to climate change and medical monitoring needs.
All right, thank you. So our clerk is not here. I kind of need to vote this out to move it along to, as I mentioned earlier, to the next, I don't know if it's going to Ways and Means. I think it might be going to both Ways and Means and Appropriations. So just timing wise, need to vote it out. But seeing that our clerk is not here, can we meet at 12:45? Does that work for everybody? Tom, would that work? 12:45 to come in and discuss. We can discuss it now, but we may want to have a motion on the table and then discuss it from there. So why don't we do
So
that?
this will be going to another committee?
Yeah, at least one of them, if not both.
Right.
Yeah, so I think it's probably both. I think it's both those means and appropriation. So, all right, so let's adjourn until 12:45 and we're off live.